good to have you back to our drafting class on deed of assignment. So, in the previous video, we listed the parts and clauses of a deed of assignment, namely the introductory part, the operative part, the miscellaneous part, and the concluding part. We said that just like the human body is divided into four parts but has various organs, that each of these parts of a deed is further divided into clauses. So now our focus in this video is to learn how to draft the clauses in the introductory part of a deed of assignment. We'll also talk about their respective functions. So I promise that we're going to be working with a scenario so that we can have a real-time examination simulation of the draft. So let's begin with our scenario. Chief Adiola Gbai of number 5, Bolorunduro, Origere, Ijoka, Akure, Ondo State, Nigeria, wants to acquire the unexpired residue of a 6-block of flats duplex located at number 5, Niger Street, Uze Zone 5, Abuja, from Jumoke Kende of number 6, Budoza Road, Ilara Moki, Ondo State. The parties have agreed to a price of 400 million naira. That's big money. The property is covered by a certificate of occupancy registered as number 49, page 59, volume 2018 at the Land Registry, FCT Abuja. The property was acquired by Jumoke Kende's late father, Kende Adebayo, via the deed of assignment dated the 10th day of March 2008 and duly registered at the Land Registry, FCT Abuja. Upon his death, his executors vested the property in Jumoke Kende by a deed of assent dated the 5th day of September 2020. And of course, if you're familiar with the bar final style of examination, you would see now answer the following questions. So let's say that the following question now says draft excuse me, draft the introductory part of the final document to be prepared in the above transaction between Chief Adiola and Jumoke Kende. And then you have a follow-up question saying state the function of each of the clauses. So let's start with the drafting of the introductory part as well as the function. So let's remind ourselves the clauses that form the introductory part of a deed of assignment. So I expect that this time around we're supposed to say it together, right? Because you've already memorized it in the previous video. So let's go together. Number 1, we have what? Commencement, followed by date, followed by parties, and finally we have recitals. So we're just going to go again, just if you missed one of the points. So this time around, I'm sure that you're going to get it. So let's just start again. Commencement, date, parties, and recitals. So let's begin with the first clause, which is the commencement. Now, what is the function of the commencement clause in the introductory part of a deed? Take note that the commencement clause, what it does is that it discloses the nature of the property law transaction. That is, when I look at the commencement clause, that is the draft in that deed of assignment, it helps me ascertain the nature of the property law transaction that is in view. Now, this is very important because there are many property law transactions that may be executed by way of deed. You have deed of lease, you have deed of legal mortgage, right? Gift intervivals, deed of gift rather. So if I read the commencement clause of that deed, I immediately know which transaction that document refers to. So if you were interning in my firm and then I said, you know what, go to my table, bring me a deed of assignment, right? So once you start checking through the documents, all you need to do is what? Look out for the commencement clause on those documents, right? Because it's going to help you distinguish it from every other document on the table. Take note that when drafting the commencement clause, ensure that it is written in capital letters. Of course, that is in the uppercase. That makes it attention grabbing, right? So please, when you are asked to draft the commencement clause of a deed of assignment, you ensure you draft it in capital letter. So, if we were to answer that question now, asking us to draft the introductory part of that deed of assignment, right, which is the final document between Chief Adiola and Jumoke Kende, our simple answer goes thus. We're going to draft it this way. This deed of assignment. So this is the commencement clause of a deed of assignment. This is simple and straightforward. This deed of assignment. So the moment I see it, oh, I know that, okay, what is the deed of assignment for? It is a final document in a scene of land transaction. So you can see that it has pointed me to or directed me to knowing that this is the transaction that this document is all about. So if you draft it this way, then you are confident that you will get your full mark. So there's no hide and seek, right? Once the question says, okay, draft the commencement clause of this document, and then you have identified it as deed of assignment, by drafting this deed of assignment, you are good to go. That is the commencement clause. Now let's move to the next clause in the introductory part of a deed of assignment, which is the date. Of course, to the layman, he knows that date has to do with the day, the month, and the year, right? Of course, that's where a layman would think. Of course, we are not saying that that is not applicable here, but you must know that in relation to deed, the provision of section 157 of the Evidence Act 2011 as amended, they are very instructive as to the effect of a date on a deed, right? So let me reproduce that section. It says, when any document bearing a date has been proved, it is presumed, please keep that word, it is presumed to have been made on the date it bears. And if more documents than one bears date on the same date, they are presumed to have been executed in the order necessary to effect the object for which they were what executed. But you also have to underline that word but, right? This word but, right? But independent proof of the correctness of the dates will be required if the circumstances are such that collusion as to the date might have been practiced and would, if practiced, injure any person or defeat the object of any law. Now, what is the implication of section 157 of the Evidence Act in relation to the date clause in a deed? The first thing to note is that a deed is presumed to be made and executed on its stated date. That is the date on a deed. The law under that section 157 creates a presumption saying that if on a document we have said this deed of assignment made this date, this 1st of January 2020, the court presumes that that was the day the document was executed, that was the day interest passed, that was when everything was finalized. But don't forget, it's a presumption. And when you look at the provisions of that section 157 again, I said you should underline that word but, right? It says, but independent proof of the correctness of the date will be required if the circumstances are such that collusion as to the date might have been practiced. So that makes this particular presumption rebuttable. So that presumption in section 157 is a rebuttable presumption, which implies that it is not compulsory, right? Or it does not imply that the date on a deed was the exact day that interest passed, which is why you must now take note of the following, of the next point that says that the date on a deed is not what determines the delivery of interest, which is very simple and straightforward. It is possible that on that document, the deed is said to be made on the 1st of January 2020, but interest did not pass on the 1st of January 2020. Now, the law allows that. The law is saying that even if you have written 1st of January, if you can prove that it was not 1st of January 2020 that interest passed, you'll be allowed. Because section 145, subsection 2 of the Evidence Act says that whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So where the court has presumed before that the date on this deed was when interest passed, a party can argue and prove and demonstrate before the court that no, although this is the date on this deed, this was not when interest passed. Which is why you must now know that date therefore does not determine when interest moved from the assignor to the assignee. I'll put it differently. The date clause does not determine when the legal interest passed from the assignor to the assignee. So that takes us into discussion of what is delivery of interest, which we have already discussed in the main tutorial video, knowing that delivery of interest can either be actual or what? Delivery might be conditional, which is delivery in escrow. What we amount to actual delivery and delivery in escrow has been purposely discussed in the main tutorial video, so we are not going to bore ourselves with that. But all you need to know is that date is not the determinant of the delivery of interest. What interest are we talking about? That legal interest moving from the assignor to the assignee. Now, you can take note of this case, which is Awojugbabe Light Industry Limited against Chinueke and Ano. So you can cite it. If you don't cite Section 157 of the Evidence Act, you can cite the case of Awojugbabe Light Industries Limited. Now, having said that, sometimes you must realize that law is step by step. Sometimes there are many things to say about a particular, fact in law, but you have to take things one after the other. So after knowing now that you know that, okay, the date on a deed, generally it is to be presumed that that was the day everything took place, right? That is the interest passed, but it's rebuttable, meaning that it is not a determinant of interest or the delivery of interest. Now, the next point to note is that it is advisable to leave a deed of assignment undated. It is advisable to leave a deed of assignment undated. Of course, it's an advice. So the next thing is to ask the question why, right? Why should I leave my deed of assignment undated? Now, the reason being that in the stages of sale of land transaction, there are 5 stages, right? The drafting of the deed of assignment is taking place in the completion stage. After the completion stage, there is what is known as the post-completion stage. In the post-completion stage, you have 3 steps, namely obtaining governor's consent, stamping of the deed of assignment, and then registration of the deed of assignment. It is when these 3 things have happened, that's when you will say that you have a perfected deed of assignment. However, before you stamp, there needs to be governor's consent. Before you can register that deed of assignment, there needs to have been the governor's consent. When you look at the provisions of Section 126 of the Nigerian Tax Act, it provides that a deed is to be stamped within 30 days of execution. And when you look at the various registration law of various states, you know that registration takes place 60 days from the date that deed was executed. And if you watch the Power of Attorney lecture video, I told you that the date, that 30 days of execution usually is calculated from the date on the deed, right? So if you have said this deed of assignment made the 1st of January 2026, the law says that 30 days from that 1st of January, you must stamp it. The law requires that 60 days from that 1st of January, you must register it. But we have a dilemma. The dilemma is that you need governor's consent before you can stamp. You need governor's consent before you can register. That is, you must have first obtained governor's consent before stamping can take place. You must have first obtained governor's consent before registration can take place. The timeline in which you will get the governor's consent is uncertain. So it's possible for somebody to submit that deed of assignment for governor's consent, and then it's taking more than 5 years, 2 years, 3 years before governor's consent will now be obtained. So let's say, for example, you have dated that deed of assignment as the 1st of January 2026, and then you submitted it for governor's consent, and you didn't get it on the December 31st of 2026. When it is now time to stamp, The law already told you ahead of time that you must stamp within 30 days, but now you have more than 11 months interval. You are going to pay penalty for those 11 months. So the best thing to do is to leave it undated. So you will now date it after obtaining governor's consent. So the effect, the reason being that why, that helps you avoid the incidence of late registration. What I mean by incidence is that penalty you are going to pay. It also helps you avoid the incident of late stamping of that deed, which is why we leave our deed undated. Now, please take note of what I'm about to tell you. This particular advice to leave a deed undated is in relation to practice. You know what I mean by practice? When they tell you this is law school, this is practice. Practice. But when you are writing the exam, please date. Don't say you are going to leave it undated. Especially when the transaction a date has been given you in the scenario, or you use the date of your examination to ensure that you date it. But in practice, you leave it undated, right? So please take note of that very important distinction, right? So let's move on to the next clause. Or before we move on, we need to look at how to draft the date clause. I was way ahead of myself. Now, how do we draft the date clause? And if you watched the draft class on power of attorney, I did mention that when drafting a date clause, it is determined by whether or not the instruction in your scenario, in the instruction in the examination hall, is asking you to draft it with a reciter or without a reciter. So you can write that what determines how the date clause should be drafted is whether or not this particular deed will include a reciter. So when this deed of assignment includes a recital clause, then you will draft it this way. This deed of assignment is made this dash day of dash 2025, right? You put the date. This deed of assignment is made this dash day of dash 2025. But when the deed would not contain a recital clause, then you would draft it as this deed of assignment made this dash day of dash 2025. So you can see that the difference between the A and B is this word is. That's just the difference. So in case you are now wondering, how would I know if a deed of assignment will contain a recital or not? Stick with the question that you are given. If the question is saying draft the recital clause, then draft the introductory part of a deed of assignment, then include the reciter. It is only when the examiner expressly says draft the introductory part without a reciter, that's when you now know, okay, the examiner does not need me to draft a recital. Then you now know how to draft your date clause. So I hope that that is simple and straightforward. So all you need to do is look at the instruction you have. So the instruction is saying draft the introductory part of a deed. It does not mention anything about without recital or not. Then you include your recital. But where it has told you expressly that draft it without the reciter, then you know how to couch the date clause. So let's move to the third clause, which is parties. 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 And you know that in a deed of assignment, a deed of assignment is an indenture, right? Which means that it is executed between parties, right? Not just one party. So, and you know that in a deed of assignment, you have the assigner and the assignee. So, because we have both the assigner and the assignee, we are dealing with two distinct parties to this word transaction. In drafting the party clause, it captures what I call these four elements. That is, there is a four-element breakdown that the party clause of the deed of assignment seeks to what capture. That is, when you look at the draft, you understand what I'm saying better. The party clause is where or is what contains the full name of the parties involved in the transaction. So where Mr. A and Mr. B, Mr. A being the assignor, Mr. B being the assignee, coming together to transact in a sale of land transaction, then it is in this party clause you introduce them to us, you give us their full name. Notice it is called full name and not abbreviation. So somebody's name is Aboyewa Elemobayo Oluwaseun. You are not going to write I.O. Aboyewa, right? Somebody's name is Zaid Baid. I'm using fictitious names for a reason. You're not going to write ZB and then just put a name there. No. You're supposed to write their full name. How would you know their full name? Their full name is as contained in the scenario given to you already. So you are not trying to look for what the full name is. Their full name has been supplied. But the caution is that don't abbreviate. What if they have alias for somebody? Maybe somebody is known as, or somebody is also known as so 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 and so. You can include it. The whole issue is so that that particular deed of assignment, you can know that these are the parties involved. Because somebody is not a party to that deed of assignment cannot approach the court to enforce what is contained. That's why you have to be careful about how you couch the name. A person who is not a party to that deed of assignment cannot come around to say he wants to enforce it. So we must know who the assignor is. We must also know who the assignee is. So I told you that the name will be supplied in your scenario, so you don't have to stress yourself. Just ensure you write the full name as it is. Now, the next important part of this party clause is that it is also in this party clause, in the deed of assignment, that you see the address of the assignor and the assignee. And of course, when I prepare, I'll say that animals stay in the zoo. So if animals even have their own address. So every human being and every legal person have an address. So whether you're a juristic person or you're a natural person, there's an address. When a company is registered, part of the memorandum of association, you have the address. A natural person has an address. So you must ensure that you state the address of the assignor and you state the address of the assignee. And this is very important. You know, it's possible for people to be sharing the same name, but then the address may help the court to distinguish, to say, even though this person is bearing so 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 name, this one we are referring to recite as so so and so. So you must ensure that you state the full address of the parties, that is the assignor and that of the assignee. Now, another very important aspect when it comes to drafting this party clause is that in drafting the party clause, it must reflect the legal personality of the parties, either as natural or juristic persons. Now, this is the point where I believe the examiner really wants to test you if you've understood all that you have been taught in class. Because there are varieties of juristic persons, which I'm going to see, and natural persons can also come in various forms. So you must be able to not only identify the legal personality of the assignee and the assignee, you must also know how to draft it to reflect their legal personality. For example, who can be the assignee and who can be the assignor? What I've done here is that no matter how the examiner wants to write or do anything, is assignor and assignee cannot exclude these people. It's either the assignor or assignee is an individual. That individual can be literate, illiterate, or blind. It's either the assignor or assignee, they are couple, right? The husband and the wife, or something joint, maybe two friends coming together. It's either the assignor or assignee family. It's either the assignor or assignee company. It's either the assignor or assignee a business name. It's either the assignor or assignee statutory body, right? So you know that it's possible for the assignee to be individual, assignor, couple. So you can mix the two together like that. So you have business name, you have statutory body, you have incorporated trustee, you have partnership, right? So the most important part of this draft is you must know how do you identify the legal personality of the persons involved in this transaction. And what I've done in the mid tutorial video is to give you a PDF where I've analyzed some of all these persons. And then there are keywords that the moment you see this keyword in the scenario, you know that this is a company. You know that this is a business name. You know that this is partnership. You know that this is a blind, this is an illiterate person. Because this legal personality must be reflected in that your draft. So if you know that, okay, this, as I know, is a company, when you now want to draft that party clause, it must reflect the fact that this is a company. I must not see the draft of an individual, whereas you're talking about a company, right? So there is how to draft the party clause of these persons. There is also how you can easily identify them, which I've already done in the main tutorial class. So I'm not going to do that here again. So the only one we just practice with is with the individual based on the scenario that we already have. Now, the next thing you must note is that this party clause also contains the descriptive words of the parties. And here, what we are trying to say is that when you talk about a mortgage, you have the mortgagee, mortgagor. In a sale of land agreement, in agreement of sale of land agreement, you have the vendor purchaser, right? In a lease, you have lessor lessee. It is in this party clause you also state the descriptive word of the parties. And in a deed of assignment, that is in a sale of land transaction, when it is now time to prepare the deeds of assignment, the parties are known as what? Assignor and assignee. It is in this party clause that you will also include the descriptive word. So if you really want to do well, especially when it comes to this draft, you have to particularly know this area, so that anytime, so even if it is even if it is lease, you already know how to draft it. Even if it's mortgage, you know how to draft the parties, and you'll be good to go, right? So let's look at the way to draft the party clause. Of course, we're working with a scenario, and in the scenario, we have the names of natural persons. Now, let me take you back to the scenario. So, the scenario we have shows that this is Chief Adeolagbai, right? This is the name of a natural person. So, he wants to buy land from Jumoke Kende. This is also the name of a natural person. So, what we have in our scenario, the legal personality of the assigner, the legal personality of the assignees, that they are both natural persons. So, let's look at how do we draft it. So, we have our commencement and date clause already, right? So, we have this deed of assignment is made this dash day of dash 2025. So, we have it already as our commencement and our date clause. In introducing the party clause, you have to start with the word between. Of course, we know that it's already between two people. But what if you have three, let's say three parties? For example, maybe I don't want to jump ahead of myself, but I'll just tell you, you can have a tripartite legal mortgage, right? Definitely you can't use between. You're going to use amongst, right? Because you have more than two parties now. But for the sake of this sale of land transaction, since we definitely know that we have those two parties, we'll start with the word between. So now watch all those four things I've said. You're going to observe it in the way we're going to draft the remaining part of the party clause. Now it says Jumoke Kende of number 6 Bulldozer Road, Ilara Mokin, Ondo State, Nigeria, as signer of the one part, and Chief Adeola Gbayi of number 5 Bolorunduro, Origere, Ijoka, Akure, Ondo State, Nigeria, as signee of the other part. Now, what have we done here? We have mentioned the name of the assigner, the name of the assignee. In how we drafted the name of the assigner, now when you look at this, you know this is a natural person. This is a natural person. What is the address? See, we stated the address clearly, and then we mentioned the descriptive word, right? If the scenario told us that Adeolagba is a chief, we also left it as chief, right? Because it does not do any harm, right? So Chief Adeolagba of number 5, Polo Rege. So you can see that this is how to draft the party clause. So what if it was Jumoke Kende Limited? How will we draft it? Must reflect that it's a company and it should not be drafted this way. Especially when we are drafting the name aspect, and then the name of the company, and then stating the address. So remember those four compartments when you are drafting the party clause. It must reflect those four things: the full name, the way you must draft it must show the legal personality, and the descriptive word must be included. The next clause to discuss is the recitals clause. So what are recitals? Simply put, they are statements of fact. That is, they tell us the story about the property before the parties came together to sign this deed of assignment, or they tell us what the parties are about to do in relation to the instant transaction, of which you know that what is the reason for drafting the deed of assignment? It is so that the assigner can Convey his legal interest in land to the assignee so that the assignee now becomes the beneficial owner to that land. Take note that there are two types of recitals. So in case you are asked how many type of recitals do we have, there are two types of recital. Number one, we have the introductory recitals, and then we have the narrative recitals. So how many types of recitals do we have? Two, namely introductory recitals, narrative recitals. What do we mean by introductory recitals? Now, introductory recitals simply explain the intention to transfer title in property. That is, this introductory recital in relation to a deed of assignment limits itself to telling us what the parties are about to do. And what are the parties about to do? What is the assignor and the assignee? Why are they coming together to transact? It is so that the assignor can convey interest to the what assignee. So this introductory recital is simply telling us what is happening right now. Now that is unlike the narrative recital. The narrative recital, on the other hand, what it does is to explain the root of title to the property, right? This time around, it would explain, it will not only tell us what the assignor is about to do, right? Rather, it will go back in time to explain how this present assignor came to own the land. So, for example, who owned the land before this current assignor? Before that previous assignor, how did that other person also get the land? So it will chronicle the history to the title to the property. So what we are going to do now is to see how to draft these recitals. So let's, before we come back to talking about the functions, so let's look at how to draft the recital clause. Now we have our commencement followed by date. So notice that you are seeing is made this dash d of dash because it's going to include a recital. And then we introduce our party clause by the use of the word between. And then we talk about the party clause, talking about the assignor. We have mentioned the full name, the address, and also stated the descriptive word of the assignor. And then we include that of the assignee. Excuse me. So when we are done writing this, we have the commencement date and parties now, right? This is how you write and introduce the recitals. You write it this way. This did recite as follows. Let's take it again. This did recite as follows. This did recite as follows. So the next question you are asking is, what is he reciting? Okay, well, as follows. As follows as in what? As in, are you going to now recite it using the introductory recital, or are you going to recite it using the narrative recital? So how then do you write the introductory recital? How then do you write the narrative recital? First thing first, you already know how to draft the recital clause, in the sense that if you are told to draft the recital clause in the instant transaction, you already know that, okay, now this did recite as follows. But you can go ahead to now say, okay, let me write the introductory recital, or let me write the narrative recital. How do you know how to draft it? Very simple. Look at your scenario. So let's go back to our scenario. So we know how to draft the recital. So we know that Chief Adeola Gbayi of number 5 Bolorunduro Onirege Ijoka Akure writes, Nigeria wants to acquire the unexpired residue of a 6-block of flat duplex located at number 5 Niger Street, right, Uze, and is going to purchase this land from Jumoke Kende of number 6 Bulldozer Ilara Moki on those states. The parties have what agreed to a price of what 400 million. So he settled that what is taking place now is that Jumoke Kende is willing to convey a title and interest in land to who now? To Chief Adiola Gbayi. Now, let's now draft the introductory recital. Let's say that what we want to draft in relation to this recital is introductory recital. And we have taught you that it simply limits itself to what is about to what happen in the instant transaction. So, how then do we draft the introductory recital? So, we'll draft our date, the commencement, and all of that. Now, this did recite as follows. So, watch how we want to draft the introductory recital now. You see that it will limit itself to what is about to happen. It tells us that the assigner is the beneficial owner of a certificate of occupancy, number 49, page 59, volume 2018, over a parcel of land with 6 block of flats situated at number 5, Niger Street, Wuse Zone 5, Abuja. The assigner is what? Willing to what? Alienate our interest, while the assignee is willing to buy, subject to the consideration to be stated therein. So you can see that this introductory recital, we have not done anything strange. All we have just done is to simply tell what is in the scenario. So how do you know how to couch your introductory recital? You simply stick with what is in your scenario. Your scenario has given you certain facts. We are simply reproducing those facts here, right? And the way we have written it shows us that this assigner wants to give interest in land to the assignee. Simple. Notice that we have not chronicled how she got the property because we are simply drafting an introductory recital. It's always safer to do this in your exam, right? Because the format is same. You can always memorize and adopt this. Only that you just ensure that the address, for example, the second part now, which is the assigner is willing to alienate her interest. If it is a man, you know his interest. So you just take note of that. And the assignee is willing to buy, subject to the conditions to be stated therein. And here, depending on what the scenario tells you, will determine how you want to write this. So let's look at how to draft the narrative recital. What is the narrative recital going to tell us? It's going to chronicle how this current assignor got title to that land. So when you go back to the scenario again, you will notice that in this our scenario, beginning from when you begin from the property was acquired by Jumoke's Kende late father Kende Adebayo, via the deed of assignment dated the 10th of March 2013, duly registered, and then upon his death, executors vested the property. You notice that he's already telling you the history of the what? Of the property. So if you were now asked to draft the narrative recital of this instant transaction now, how would you draft it? I would take it to be that you know how to draft the commencement date parties and you already know how to introduce the recital, which is this did recite as what follows. So now watch how we're going to chronicle that instant scenario we have now. We're going to chronicle it. By deed of assignment dated the 15th day of June 2005, registered as number number 12, page 2, volume 2010, Kende Adebayo became the owner in fee simple of the property hereinafter described and subsequently died on the 10th of January 2022. Probate of the last will and testament of the deceased was on the 20th day of May 2022, granted by the High Court of Justice, Family Division, Principal Registry to Eleanor Smith, Adeola Deborah, right, as executors. By deed of assent dated the first day of July 2022, the personal representative that those executors vested the property in Jumoke Kende, the assignor, who is now the beneficial owner and has agreed to assign the same to the assignee for the consideration herein after appearing. The assignor is willing to alienate her interest, while the assignee is willing to buy, subject to the consideration to be stated therein. So you notice that what this narrative recital has done is to simply what? Chronicle the history of the land. And we have just restricted ourselves to the scenario that we have. So what if you don't have all these elaborate details given to you in the scenario? Then just write introductory recital, right? Because if the examiner now says, maybe the examiner did not even go into this scenario, then he says, okay, draft a narrative recital, then you improvise, right? You can improvise. But the moment there is nothing as to telling you to draft a narrative recital, then stick with just writing the introductory recital. It will still what suffice. So now that you've seen a sample of what a recital looks like, let's go back to talking about the functions of recitals. The functions of recitals. The first function of a recital is that the party making such statement is estopped from denying the fact as stated therein. And that is as provided for under section 169 of the Evidence Act 2011 as amended. So let's read that provision. That provision is to the effect that when one person has either by virtue of an existing court judgment, deed, right, which is why we're reciting this session, deed or agreement, or by declaration, act or mission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative in interest shall be allowed in any proceeding between himself and such person or such person's representative in interest to deny the truth of such thing. So you can see that this has created an Estoppel, right, against the party making the assertion. So, for example, Jumoke Kende has asserted that, see, I got this land from my late father. He willed it, and via deed of assent, the title to that land was vested. She can't come back in the open court to say, I didn't say that, oh, I didn't say that, oh. The section 169 of the Evidence Act has already stopped her from denying the statement as contained in this recital. Another function of a recital is that it creates a presumption of accuracy of fact contained therein. It creates a presumption of accuracy of fact contained therein, and that is for that we'll see the section 162 of the Evidence Act. It provides that recitals, statements, descriptions of facts, matters, and parties contained in deeds, instrument, act of the National Assembly, or statutory declaration 20 years old. So notice this, please, 20 years old or more as the date of the contract in which such deed, instrument, or other document is sought to be relied upon shall, unless and except so far as they may be proved to be inaccurate, be taken to be sufficient evidence of such fact, matters, and description. So please notice that this particular presumption for it works in tandem with a specific number of years. So notice that's why I said you should take note of 20 years old or more, right? So what the implication of this section 162 is that if a particular deed of assignment is 20 years old or more, the court will presume that every statement of fact in that recital is completely accurate. So if a particular dispute, right, today now arises over that land, and then you present and you tender that deed of assignment, right? Let's say that the deed of assignment was executed in 1985. Let's just verify that the 1985, and this is 2025, right? 2026, whichever one you are living in. The court will rely on section 162 and take the facts written in those recitals as true. So now the burden of proof will now shift to the opposing party to show that they are inaccurate. So the moment it tenders, so for example, let's say I'm the party that is demonstrating through that deed of assignment signed in 1985. Whatever is in that recital, I don't need to call any witness to prove it. Let's say that recital already says, okay, this is how this family got the land. It chronicled how the family got the land, and that was where I derived my title. The moment I tend that, I don't need to. All I need to do is just direct my lord in my written address. Duty now behoves on the opposing party to say, okay, we need to this presumption is rebuttable, but the burden of proof has already shifted to that other party to disprove what the court has already presumed as what true and accurate. But please note that number of years, right? So that you know when that section 162 applies. The final function of a recital is that it can be used to clear any ambiguity in the deed. Now, we are all humans and we make mistakes. And sometimes there are some clauses, this time around now, This particular mistake we are talking about is not for you. It's not for you in your bar finance. So don't say, okay, if they ask me to imagine maybe in the bar finance, they ask you to draft a deed of assignment. Let's even say it's possible. And then maybe you now drafted and maybe you omitted some clauses and say, don't worry, they'll use my reciter to correct any ambiguity. The answer is no. So this one is real life application. This particular third point is for real life application. Where there might be ambiguity in the operative part of a deed. Let's say, for example, let's say maybe it's not this might not be visible, but let's just say that maybe it happened that the lawyer did not include the consideration clause. So we don't even know the amount. But he included it in the recital. What will happen is that the court will rely on that recital to clear whatever ambiguity. Let's say that the parcel clause that ought to give us the exact description of the land. Let's say there's an error in the way it was couched, right? What the court may rely on is the recital. If the particular parcel of land was accurately described in the recital, the court can look at the recital and then use it to do what to say that okay, this is exactly the parcel clause that the parties have agreed upon. It may also happen because there's what is known as the addendum clause, right? And that addendum clause, there's how to draft it that you will be able to know that whether is this a lease or a deed of assignment where it has not been properly drafted. Let's say, for example, in that introductory recital, it has already said the assignor is willing to alienate our interest in land to the assignee. So if there is a mistake in how the addendum clause was drafted, because that the addendum clause is very important, it lets us know are you really giving everything or you are giving. No, it's possible that in the addendum clause will state are you giving out all your interest or you are giving just part of your interest. Let's even say that there is no ambiguity. We would use the recital to clarify that what ambiguity. So, but I've told you that ambiguity is not for you. That one is when you're in practice, right? But not for your bar finals. You draft it properly. So we have come to the end of discussing the introductory part of a deed of assignment. So you can see that we have carefully answered our scenario question. Of course, if you are asked in the exam mode to draft the introductory part, I'm not asking you to go and list out everything, then do it separately. No, you follow the instruction. The instruction is draft the introductory part, so you simply draft. The next question now says list the function. That's when you can now say, okay, number two, then you start listing, okay, name, and then you talk about the function, you talk about parties, you talk about the function. So in the next video, we're going to look at the operative part of a deed of assignment. That is how to draft the clauses in the operative part of a deed of assignment. So please, if you are here to subscribe, I think one of the way you can say thank you, three ways. One, you subscribe to this channel. Two, you share this with your friends. And number three, you do well in your bar finals examination. So I'll see you in the next drafting class video.